Good afternoon, everyone. Tan Sri Mohamed Ariff bin Mad Yusof, International Arbitrator, AIAC Advisory Board Member, former Speaker of the Dewan Rakyat, retired Judge of the Court of Appeal, Mr. Wilfred Abraham, Consultant Zulrafiq and Partners, Datuk Sundra Rajoo, Director of the Asian International Arbitration Center, Mr. Michael Chai, AIAC Advisory Board Member, members of the Expert Advisory Committee of the AIAC SFC, distinguished guests, ladies and gentlemen, a very warm welcome to the Asian International Arbitration Center, or more commonly known as the AIAC. First and foremost, let's acknowledge the reason we are all gathered here today, the standard form of building contract, a cornerstone document in our construction industry. The AIAC standard form of building contract is a significant milestone for the AIAC. The latest edition of the SFC serves to refresh and remind the stakeholders of the construction industry, from architects to engineers, from contractors to clients, of the critical role that the SFC plays in safeguarding interests, ensuring fairness, and upholding standards. This launch is also part of our efforts to promote the dispute prevention and avoidance mechanism in the construction industry. Ladies and gentlemen, to begin the event, we would like to call upon our Director of the AIAC, Datuk Sundra Rajoo, on stage to deliver his welcome remarks. Please welcome Datuk Sundra Rajoo.
Yang Bahagia Tan Sri Muhammad Ariff bin Muhammad Yusof, Mr. Michael Chai, both members of the AIAC Advisory Board, Mr. Wilfred Abraham, and also Mr. Lam Wai Loon, and other members of the Expert Advisory Committee. It is like the gathering of in a Western, the good guys are back again. So, and then as esteemed members, distinguished guests, and then ladies and gentlemen, a very good afternoon to you. Thank you so much for being here. And for those who are joining us virtually, thank you very much. I think we have more virtual people joining us. I think it's double the number that we have here in the hall. And then I also want to recognize the Expert Advisory Committee who has gathered here to, very short notice, we had to get this contract out. So, and then I think the last time the contract was done was actually in 2019. So 2024 marks a significant time for us to do a relaunch. And we have essentially maintained the contract, but we want to say that I just want to trace a little bit about history of this form. In 2017, AIAC decided to launch this form, and I think we decided to do it in a slightly different way at that time. We said that it is not going to be issued by a professional institute. It's issued by a dispute resolution center. The reason being is at that point of time, we said that we realized a lot of issues were coming out from contracts, were coming to disputes. Perhaps by handling the contract itself, we will reduce the disputes, go into dispute avoidance. It's actually a long-term plan. And then I actually appreciate at that time, the Expert Advisory Committee, which essentially still the same people. The first draft, I must recognize, was done by Mr. Lam Wai Loon. And I still remember where he used to work, and he was a younger man then, more energetic. I think he had more time. Now he's a very busy practice. You're almost like impossible to get him, but, like everyone else, some of us have retired, others have continued, but everybody is busy again after COVID. It's very interesting. Now, the emphasis driving the standard form building contract including 2024, is to improve the continuity of work and enhance the working relations between all the people who are participating in the construction process. So, and then we wanted also to bridge the gaps that we see in the existing forms, which is normally issued by, it's very interesting, the standard forms building contracts that are issued in Malaysia is mainly from PAM, which is the Pertubuhan Architect Malaysia. Then you have CIDB has come out with a form, and then we have come out with a form, and then I think various forms which we see in the system, much of it is bespoke. So one thing is that this is one form that we made it available free. There's no copyright. So you can actually take the form, which is available on the website. You will download it. We have not given you a hard copy. Eventually, we will give you a QR code. This is the new way of doing things. My very young, energetic team tells me, there's no more printing of paper. You have to actually take a QR code, and then you will have your contract in your phone or anywhere you want. But I want to talk about some of the principles or characteristics the contract has. First thing, as I think we still maintain, we have eliminated the issue of quantities. So there's no quantities. It is one consolidated form, so you can use it for both. The second one, we have brought in no more a professional, but a contract administrator who does the certifying. And so it's an opening up in the traditional Malaysian system. It's always been an architect or an engineer who are not going to be changed. I don't think so it's going to change. Most of them will be the contract administrator, and in the government it will be a supervising officer. So it is not going to change. Then the other thing that we also maintain is the distinction between the duties and the obligations of the parties, so that there is a better working relationship. And then I think most people here are very familiar with statutory adjudication. This is one of the forms that is SIPA compliant. So we recognize that SIPA is there, and it will allow the mechanism to kick in because it's a statutory kick in. And then we also have put in all the latest legislative changes and record. And one of the other things that we also have is some new provisions earlier, which was in the 2019 form, peculiar clauses like targeting bribery and corruption. I mean, bribery and corruption is legendary in the construction industry. So we tackle it as one of the issues. So I think the other thing I want to say is that this is also a form which was done originally by working with a lot of people. And AIAC is committed to collaborate with everyone to promote dispute resolution, dispute avoidance, dispute settlement, and any form of educational arrangements in the center. So we are launching something tomorrow which is quite unique, which is a recognition of our special position in the world as a Muslim majority country, and we are significantly identified in the world as somebody who has this ability in a diverse society together to handle the thing. So tomorrow we are launching what is called the Islamic Sharia compliant standard form building contract. In fact, I had to do that because we are doing it tomorrow. Today I had to launch the conventional form, which mirrors. And then I think if you come tomorrow, if you're available to come and see the Sharia compliant contract, which is done by Tun Zaki and an expert committee, which took this conventional form and then made it Sharia compliant in the way by going through each clause and also looking at the overall mechanism. And it is a very, very interesting standard form building contract. So we will leave that for tomorrow. But today we have our conventional form. And then I want to thank all of you all on this afternoon, particularly my board members. I have 2 board members here. And then I want to also thank, I called Wilfred and I said, Wilfred, you actually wrote a foreword for my book in 1998. I think time for you to actually give a keynote address, because he's actually a consultant in Sul Rafiq. But I remember long time ago, we will always be talking about construction law in the old days. And, so I'm very, very fortunate. I'm very grateful. So I told him that he has to be a bit more active back into the system again. So anyway, thank you so much. The next step that we are going to do is I want to tell you all that we are going to do a lot of promotional work in the country particularly and without the country. And we are going to do it with y'all. We will be asking various members and firms and people who are involved in the industry to join with us, and we will do interesting events, not marketing the products. The products will be maybe an example, but we will talk and increase the awareness in about dispute resolution, dispute settlement, about dispute avoidance, and particular aspects of practice and law and other things that will help us in the long run. So I look forward to seeing you all again, and thank you so much for being here. Thank you so much.
Thank you so much, Datuk Sundra, for your welcome remarks. Distinguished guests, ladies and gentlemen, without further ado, we would like to call upon Tan Sri Mohamed Ariff bin Mad Yusof to deliver the opening remarks. Please welcome Tan Sri.
Datuk Sundra Rajoo, Director of the Asian International Arbitration Center, AIAC. Mr. Michael Chai, a member of the Advisory Board of AIAC. Mr. Wilfred Abraham, Consultant Zul Rafiq and Partners. Esteemed members of the Expert Advisory Committee, who are very well represented today, I see. Distinguished guests, ladies and gentlemen. Assalamualaikum, salam sejahtera, a very good afternoon, and a warm welcome to all present. I'm very pleased indeed to welcome everyone present today to the official launch event of the AIAC Standard Form Contract 2024. When I say everyone present, it will include those physically present and those virtually present, and we've been very pleasantly told that there are more virtually present than those who are physically present here. But anyway, it's a full house today, even here. The 2024 edition of the AIAC Standard Form Contract represents a momentous advancement of the Centre's efforts in expanding the promotion of dispute prevention and dispute avoidance mechanisms in the construction industry, something already touched upon by Datuk Sundra Rajoo a while ago. As a member of the AIAC Advisory Board, I am truly impressed by the innovation, high spirit, and the momentum that the Centre is striving to maintain as we enter this new year, the work that has been splendidly done thus far. In keeping with this momentum, I understand that tomorrow will mark yet another milestone for the Centre, as they are set to achieve another significant feat with the launch of the AIAC Islamic Standard Form of Building Contract, also alluded to by Datuk Sundra a moment ago. I take this opportunity, therefore, on behalf of the board, to extend my heartfelt congratulations to AIAC for their commendable efforts and impressive achievements. At the outset, allow me to express my earnest appreciation to each and every expert advisory committee member for their wisdom, invaluable time, and feedback in formulating the draft standard form contract 2024. Their expert inputs and perspectives have always been instrumental, among others, in streamlining the provisions that cater to the demands of the users and industry players throughout the consultation process up until today's official launch. On behalf of the AIAC, therefore, I would also like to thank all speakers, moderators, and participants, both attending physically and virtually, for your unwavering support in making today's event a reality, and obviously it will be a success. Ladies and gentlemen, as our domestic construction industry continues to advance to greater heights post-pandemic, charting a significant 9.6% year-on-year growth in the third quarter of 2023, I think we can be optimistic that the revival of several huge infrastructure projects in this country will drive sustainable growth of the Malaysian construction sector. In the same vein, the acceleration of numerous other construction projects by the government or public sector, such as railway and road network infrastructure, will strengthen the growth of the construction industry in the coming years. In resonance with this, the stakeholders and industry players place high expectations on a swift and efficient dispute resolution mechanism that commensurate with the credible performance of the domestic construction industry thus far. On the one hand, we are cognizant, of course, that the Construction Industry Payment and Adjudication Act 2012, CIPA, was introduced with the aspiration to facilitate regular and timely payment and to provide a speedy dispute resolution mechanism through adjudication in the construction industry. AIAC, as the sole adjudication authority mandated under Section 32 of CIPA 2012, has recorded a total of 683 adjudication cases, with the total amount in dispute documented at a little bit more than 1 billion Malaysian ringgit in 2023, which is very impressive. In the meanwhile, too, our 2023 case statistics also charted an aggregate of 59 construction-related arbitrations, which works out to be 57.28% of arbitration cases registered so far, being referred to the AIAC for dispute resolution. I think we can give ourselves a slap, congratulating slap on the back for having this kind of statistics in AIAC. While AIAC strives to offer world-class institutional support for dispute resolution, it is of course fundamental to understand and acknowledge the role of dispute avoidance mechanisms in the construction industry. Unlike dispute resolution procedures, the dispute avoidance mechanism is often incorporated in the written contract to eradicate any possibility of disagreements from escalating into disputes. It is indeed a proactive and practical approach that involves both a proper management of conflict and in particular for the avoidance of undesirable disruptions to the construction projects. Ladies and gentlemen, it is evident that the AIAC standard form contract has evolved to address the dynamic needs of the construction industry, and as such, it is an ideal model of a dispute avoidance mechanism that specifically caters to the changing needs of the construction industry. This edition of AIAC SFC 2024 represents a streamlined version of AIAC 2019 standard form building contracts launched back in 2018, which is tailored mainly to resolve the issues and challenges plaguing the construction industry. While there is a spectrum of standard form construction contracts domestically, this latest edition of AIAC SFC stands as a hallmark innovation that embodies the current best practices with strict SIPA and local laws conformity, also alluded to by Datuk Sundra a moment ago, to meet the high expectations and standards of the stakeholders. Today, we are proud to announce that the AIAC SFC 2024 remains as a free of charge, customizable, and publicly accessible dispute avoidance mechanism, without the hard copy, of course. It is notable that the AIAC SFC 2024 still provides sufficient room for continuous review and improvement to be undertaken as the domestic construction industry flourishes. With that in mind, I am confident that today's panel discussion, which will follow, will bring to light the comparison between the standard form contracts in the Malaysian construction industry, zooming into the key features, similarities, and differences. Meanwhile, the second session of the day will explore the prospects of the standard form contracts and how best they will serve the expectations of the construction industry in the years to come. With the specially curated sessions for the day, I believe that all of us will be able to draw significant practical insights and strengthen our understanding of the standard form contracts and the construction industry in Malaysia and beyond. I wish, therefore, all the best in your deliberations this afternoon. Thank you for your attention.
Thank you very much, Tan Sri, for your opening remarks. It is our utmost privilege to have you here at our launch ceremony. Ladies and gentlemen, we would now like to call upon Mr. Wilfred Abraham to deliver the keynote address. Let us all welcome Mr. Wilfred.
Tan Sri Muhammad Ariff bin Yusof, former Speaker of the Dewan Rakyat, retired Judge of the Court of Appeal and a member of the Advisory Board, Mr. Michael Chai, member of the Advisory Board, and Datuk Sundra Rajoo, Director of the Asian International Arbitration Center. Also, esteemed members of the Expert Advisory Committee, and not to forget our distinguished guests, ladies and gentlemen. Good afternoon and welcome to this launch of the AIAC forms. Before I start, I'd like to tell you all that after hearing what Sundra Rajoo has spoken, my speech might sound repetitious. I'm sorry for that, but please bear with me. I would also like to thank the AIAC and Datuk Sundra Rajoo for inviting me to give this keynote address. It is indeed a privilege to be asked to do so. And I am happy to deliver this keynote address. Today, as we embark on this momentous journey, which we not only symbolize progress, but demonstrate a profound commitment towards excellence and innovation within the construction industry. This commitment serves as a testament to the AIAC's dedication to being a beacon of growth, adaptation, and unwavering dedication in providing innovative solutions to the challenges faced by the construction industry. The construction industry, both on a global and domestic scale, has encountered unparalleled challenges, particularly in the aftermath of the global pandemic. Nevertheless, as the statistics just shared by Tan Sri Muhammad Ariff earlier underscore a remarkable 9.6 year-on-year growth in the Malaysian construction sector in the third quarter of 2023. In other words, the construction industry has made a significant contribution of about 53.44 billion ringgit to the national gross domestic product in 2022. This noteworthy growth serves as a testament to the industry's resilience and adaptability, driven by the resurgence of mega infrastructure projects and government initiatives. As evident, the construction industry plays a pivotal role in the Malaysian economy, impacting not only those directly involved, but those also the overall well-being of the citizens. Hence, it is crucial to have a strong industry that minimizes the occurrence of abandoned or delayed projects stemming from unresolved disputes. Furthermore, given the current global growth in the construction sector, there is an opportunity for Malaysia not only to bolster its economy, but also to emerge as a leader in international construction reform. It is imperative to recognize the pivotal role that dispute avoidance mechanisms play in the construction landscape. Unlike dispute resolution procedures, which come into play after conflicts have arisen, dispute avoidance mechanisms are proactively integrated into written contracts to prevent disagreements from escalating into full-blown disputes. This proactive and practical approach is an integral part of effective project management, aiming not only to manage conflicts, but also to eliminate the potential for undesirable disruptions to the construction projects. In essence, dispute avoidance mechanisms act as a preemptive strategy to identify and mitigate potential sources of conflict before they can adversely impact the project. These mechanisms are strategically crafted within the contractual framework to address common pain joints, uncertainties, and areas prone to dispute. This aligns with the AIAC's commitment to not only providing robust dispute resolution services, but also to fostering an environment where conflicts are minimized and projects progress seamlessly. The incorporation of dispute avoidance mechanisms reflect a forward-thinking mindset within the construction industry. It emphasizes collaboration, open communication, and a shared commitment to project success. By addressing issues at their root and implementing preventive measures, construction stakeholders can create a more conducive environment for the successful project delivery. The AIAC, cognizant of these principles, stands ready to support the industry in embracing and implementing effective dispute avoidance strategies, ultimately contributing to the overall growth and sustainability of construction projects. Notably, the AIAC stands as a trailblazer, being the first international arbitral institution globally to introduce its standard form of building contracts. These contracts also hold the distinction of being the pioneers in incorporating provisions that cater to the statutory requirements under the Construction Payment and Adjudication Act 2012, commonly known as CIPA 2012. Distinguished guests and ladies and gentlemen, the first edition of the AIAC standard form contracts were initially launched in 2018 with a predominant aim at fortifying Malaysia's construction industry and reducing the number of disputes. To achieve this objective, AIAC SFC proactively addressed potential issues, emphasizing the preventive measures to stop problems before they arise. Upon assessing the practical implementation of the AIAC standard form contracts in the construction sector, it became evident that there was more room for improvement. Consequently, in 2019, the decision was made to revise and further elevate the existing AIAC standard form contracts, leading to the launch of the AIAC 2019 standard form building contracts and subcontracts, what is known as the AIAC 2019 standard form contracts. The objective was to build on the success of the AIAC standard form contracts and address any remaining aspects that required refinement. One notable amendment to the in the AIAC 2019 standard form contracts was the incorporation of the contract administrator's role. Upon observing the industry, we knew that the introduction of the contract administrators could bring significant benefits. By assigning the role of the contract administrator, architects, quantity surveyors, engineers, and other stakeholders can actively contribute and expand the scope of their responsibilities, fostering a more comprehensive and collaborative approach within the construction process. In 2021, the AIAC acknowledged while the standard form contracts contain clear provisions, users could derive added value from supplementary insights and practical guides and optimizing the use and administration of the contract through a project's life cycle. Consequently, the AIAC launched the Standard Form Contract Manual, which serves as a valuable resource providing practical insights, interpretations, and examples. Its purpose is to assist users in gaining a deeper understanding of the nuances inherent in the AIAC standard form contracts, ultimately enhancing their ability to effectively utilize and administer the contracts in various project scenarios. Distinguished guests and ladies and gentlemen, I would like to take this opportunity at this moment to acknowledge and thank the members of the Expert Advisory Committee for their invaluable wisdom, dedicated time, and constructive feedback during the development of the AIAC Standard Form Contract 2024. Their expertise has played a pivotal role in defining the provisions to meet the demands of users and industry players leading up to today's official launch. The AIAC Standard Form Contract 2024 aims to optimize construction projects through several key objectives. They prioritize the timely completion of work by establishing clear timelines and milestones. Additionally, these contracts emphasize accountability and transparency, fostering trust among stakeholders through well-defined roles and transparent communication. Ensuring clarity, well-defined terms, and unambiguous mechanisms, the AIAC Standard Form contracts mitigate the risk of disputes arising from misunderstandings. Ultimately, their purpose is to build trust, prevent acrimonious disputes, and promote compliance and consistency for the seamless execution of construction projects. This 2024 edition it represents not just an update, but a significant advancement in industry practices designed to reflect the latest best practices and showcase our commitment to the innovation and excellence. In conclusion, the AIAC Standard Form Contracts 2024 represents more than just an update. It just signifies a significant advancement. It is a manifestation of our collective commitment to the innovation and excellence, paving the way for a future where construction projects can thrive seamlessly. Thank you for your attention, and I look forward to witnessing the positive impact of the AIAC Standard Form Contracts 2024 on the construction industry. Thank you once again.
Thank you, Mr. Wilfred, and we kindly request you to remain on stage for the launch. Today's event is indeed a manifestation of our collective commitment to innovation and excellence, paving the way for a future where construction projects can thrive seamlessly. Joining Mr. Wilfred on stage, we would like to invite Tan Sri Mohamed Ariff, Mr. Michael Chai, and Datuk Sundra Rajoo to come up to launch the AIAC Standard Form of Building Contract 2024. We humbly invite Tan Sri to place his palm on the screen on my count. Are you ready? 3, 2, 1. With that, we'd like to thank Tan Sri for launching the AIAC Standard Form of Building Contract 2024. Yeah. Yes. We kindly request Tan Sri, Datuk Sundra, Mr. Michael, and Mr. Wilfred to remain on stage. And now we would like to invite the esteemed members of the AIAC's Advisory Board and the AIAC's Expert Committee to join us on stage for a photo session. We would like to welcome Dr. Chan Yuan Ng, Mr. Gananathan Patmanathan, IR Harban Singh, SR Isaac Sundarajan, Mr. Kevin Prakash, Mr. Lam Wai Loon, Mr. Mak Hon Pan, Dr. Ong Silian, Mr. Un Chi Keng, Mr. Rajendra Navaratnam, Mr. Ramdas Tikamdas, Mr. Rodney Martin. And Mr. Belden Premalach. Thank you, everyone. You may now proceed to take your seats. We would also like to announce that the AIAC Standard Form of Building Contract 2024 is now accessible through QR code provided on your tag. So for those who have not yet registered at the lobby, please do so at any time during this conference. Ladies and gentlemen, we would now like to proceed to the first session of the day. This session is entitled Construction Industry in Malaysia, Unweaving the Key Features, Similarities, and Differences of the Standard Form Contracts. This session will be moderated by Ms. Janet Chai. Ms. Janet Chai is a partner of Chui & Company. Her practice focuses on commercial, energy, construction, and engineering disputes. Ms. Janet has been an accredited adjudicator with the Asian International Arbitration Center since 2014. We would now like to call upon our moderator for this session, Ms. Janet Chai. Let us all give her a round of applause.
Hi, everyone. Good afternoon, everyone. Firstly, thank you so much to AIAC for inviting me to be part of this launch. Very, very pleased to be here, very honored to be here. I would like to now call upon the esteemed panel of industry speakers who will be joining me on stage this afternoon to explore the similarities, differences, and hopefully the key features of the 2024 AIAC SFC. All of these individuals need no introduction at all. They are industry speakers whom you have seen at all of AIAC events. Firstly, I would like to call upon Rodney Martin. Rodney is the Chief Executive of Charlton Martin Group, having previously been employed as Group Regional Director and Senior Vice President of two major contracts consultancy groups in the Asia-Pacific region. Yes. And next, I would like to call upon Mr. Harban Singh. All of you would know Harban Singh as a professional and chartered engineer, chartered arbitrator, mediator, and adjudicator. He's called to the Malayan Bar in 1995. He is at the moment, however, not in active practice and an advocate and solicitor. And last but not the least, we have Lam Wai Lun with us as well. Wailun, as you all know, is an active advocate and solicitor, a partner at Mercer's Harrell and Lam Partnership, a chartered arbitrator, and a fellow of the Chartered Institute of Arbitrators. Good afternoon, gentlemen. Thank you so much for joining me on stage. Now, as we have all heard from the opening remarks, keynote addresses, and we all know that the key benefit of standard form contract is to provide clarity, certainty, and consistency to ensure that parties are on the same page, having a clear understanding of their obligations, have access to the same information, and are aware of the standards and requirements for the construction project. The other aim of SFC's standard form contracts, of course, is to such that if all parties are aware of their rights and obligations, it would reduce the risk of disputes and therefore legal action. And one other point of clarity and certainty is, as alluded to by Wilfred earlier, the availability of dispute resolution mechanisms, such as mediation or arbitration, that are usually provided for in the standard form contract. So here we are this afternoon into another launch of the AIAC standard form contract. 4 years later, the second edition of the Red Book, Yellow and Silver Books took more than 18 years to be launched. And of course, the size of the 2017 versions of the FIDIC, as you all know, they are 50% longer than 1999 versions. So the length of it may have some part to play in the time taken, that is 17 years. Now, going back to the point of this session, our esteemed panel of industry experts before you today will do a comparison of the 2024 AIAC standard form contract against the other standard form contracts typically used in the market. So we will be doing a comparison against FIDIC, JKR, CIDB, and PAM standard form contracts. Now, against these other standard form contracts, we will highlight the similarities and differences of the 2024 AIAC SFC. Whilst we attempt to do this, we hope that you will be able to see the key features of the 2024 AIAC standard form contract. If you have any questions in this regard, we will attempt to take them. In any event, as you know, this is only the first session. You may be assured that the second session, also with a panel of very esteemed industry speakers, they will definitely address the queries if left unanswered in the first session. Now, the format of this afternoon session, there are so many areas to cover, but we will only focus on 4 main areas. And these are the areas that usually lead to disputes. That is payment, variation, extension of time, and loss and expense. How we're going to split this up among the industry experts here with me this afternoon is Harbans, with his depth of experience, he will cover CIDB and JKR forms. Wailun will take PAM, and we have left the most complicated standard form contract FIDIC to non-lawyer and expert Rodney. With that, if I may introduce one of you to start. Harbans?
Good afternoon, ladies and gentlemen. I've been asked to start. I will give just a general statement first, then perhaps we can pick up from there. I mean, we have been talking about standard forms and all that. I just want to give a view, a bit on what we mean by a standard form. I think if you look at it, the JKR standard form is really not a standard form, the way we understand what a standard form is supposed to mean. Because a standard form is one which is arrived at with input of all the stakeholders. And JKR forms are only standard for the particular employer. That means JKR. Okay, so that is a starting point. To me, if you ask me, the only really standard form in the industry was the CIDB 2000 form, where I think there was very extensive engagement with all the stakeholders. I'm not so sure. I think, I don't know whether you're aware, CIDB has come out with a latest form. I think they call it the 2002 edition, which has been recently launched. I do not know here whether we have the same level of engagement with all the stakeholders. But what I can actually testify, the CIDB 2000 form was actually really a standard form. The rest are basically institutional forms. They're standard for the institution. Okay, and one short comment before I'll let my fellow panelists take over. I've been taking part in a lot of this kind of discussions on standard forms and all that. And those days, I always used to be very judgmental. People used to ask me which form is better than another, which is correct. Now, after being an old man, I'm already old now, with lots of years of knocking around. Okay, I will give an answer. All of them are correct in their own way. It's depending who is looking at it. What is the basic philosophy behind them? Each one of them got a different philosophy. JKR has got a different philosophy. PAM has got a different philosophy. AIAC has got also a different philosophy. So if you look from their point of view, I think it is all correct. Okay, so we can comment on what we think are the shortcomings and all that, but we are looking from a different point of view, whether you are a contractor or whether you're an employer or whether you're an arbitrator, you see. So this is basically my introduction. I want to set it such. Any comment we make is not basically a criticism. Any shortcoming, so-called perceived, is only a perceived shortcoming. It's our perception only, something we can look into and we can discuss. Okay, Mr. Lap, I pass it to you now.
Yeah, I'm going to comment about the PAM form contract. Actually, if you are familiar with PAM form contract, you know about a few things. First, AIAC form, they look very similar to the PAM form contract, but they are in many ways not the same. Now, why is it so similar? Because we have to understand the Malaysian context. In the private construction sector, most of the standard forms that are being used is PAM form contract as a starting point, and thereafter they modify it in a way that is either more favorable to the employer or more favorable to the contractor, and some to a small extent they just adopt PAM form as it is. But whatever it is, there are a lot of similarities in terms of structure, mainly because people are familiar with it. So when people are familiar with a particular form, then they will use it. So even if you might have a very good standard form, and at the end of the day, nobody uses it, it means nothing. There is no value in that particular standard form. So the first part why AIAC standard form is drafted in such a way is to give familiarity to the potential users, to encourage them to use the form. And from there on, we added a lot of good features in the AIAC standard form contract, and we tried to improve the construction industry. And how do we actually improve from a contracting point of view, the construction industry? Especially, as you know, we targeted the private construction sector, first to draw them into using AIAC form because of familiarity. And when they use it, they start to enjoy a lot of the improvements made in the AIAC form. Now, generally speaking, like Datuk Sundra and Mr. Wilfred has pointed out earlier, dispute avoidance. It is a very general statement, but how do you find dispute avoidance in a standard form contract or a building contract, a construction contract? I think one of the main feature that you can actually put in the contract to try to avoid dispute or a problem from being escalated to a big dispute or acrimonious dispute is to provide a clarity. Clarity, it means clarity in the important terms used in the construction contract so that people understand it, the users understand what do they mean and how what is the impact of those terms? Like for important terms, like for example, force majeure. Nobody even care about this particular term more than now. I think after the pandemic, people are looking through force majeure definitions and see whether it actually covers the pandemic or not, COVID-19 pandemic. But these are the issues. And secondly, is about the mechanism, clarity in mechanism. You do not leave mechanism like, for example, application for extension of time, application for loss and extension. These are important clauses. Leaving them uncertain. When do they have to make the application? And when they make the application, when the contract administrator will have to attend to it. What if the contract administrator does not attend to it in a timely manner? What would be the impact? And so on and so on and so on. So that you have a clear procedure. When you have a clear procedure in a contract, everybody knows what is their obligation. And therefore, you can provide a clear solution, a guidelines to the people who are going to use the contract. I think these are the important things that some of the important things that you can find in the AIAC SFC contract. That's all I wanted to say. General comment. Thank you.
I got it done. Okay. If I could just add on to that, the point that before I go into a little bit about FIDIC, which I'm going to compare to the AIAC contract this afternoon, adding on a point to what Wai Loon said about avoiding disputes. I think there'll always be disputes. So avoidance completely from the beginning is not practical. What we need in good standard forms of contract are efficient mechanisms to deal with the disputes when they arise immediately. And one mechanism that the FIDIC form of contracts is famous for is the DAB, the Dispute Avoidance Board or the Dispute Adjudication Board, which is there in the contract to sit on the project. The best form is a standing DAB, which means the 3-panel or 1-panel board is appointed from the beginning and deals with issues as they arise and avoid them going to costly, lengthy arbitration or court matters and wasting a lot of time and money. So that's one issue about standard forms, and that's what FIDIC's known for. Now, before we go into the 4 topics, if I can just say a bit about FIDIC. Some of you will have used FIDIC contracts, some of you will have amended them, others may be familiar with the term but not actually know where FIDIC came from. And I just wanted to say FIDIC is the French acronym for the International Federation of Consulting Engineers. It was formed in 1913 by 3 countries in Europe, Belgium, France, and Switzerland, to represent engineers globally. There was a need for a standard form of contract to be used around the globe as major infrastructure projects were being developed at that time, and the popularity grew. There are now over 100 member countries of FIDIC. It is also known for publishing this suite of international construction contracts, used, would you believe, by 30% of the projects, international projects globally. So it's the most popular standard form of contract internationally. Uniform and consistent framework is a key to the FIDIC contracts. There's the red book, the yellow book, the silver book, red book for employer design, yellow book for contractor design, silver book for turnkey, and there are other colors in the rainbow as it's known, but they use consistent terminology. 20 clauses originally in the 1999 forms, which I'm going to talk about, and then there was an update to these forms in 2017. So the point I want to make about the introduction is, where have these forms come from? They've come from an international perspective, from engineers, and that's why the contract administrator in FIDIC is an engineer. Also, because it's an international contracting arrangement, there was a perception that contractors needed more protection because they take on more risk when they go to developing countries where there may be no familiarity with the local industry. If there is an industry at all, there may be more uncertainty about getting paid and so on. So the reason why FIDIC is perhaps not so popular with some employers is it's perceived and is a fairer contract in terms of getting paid. And I'll talk more about that in a moment. But that's an introduction about FIDIC contracts. as I said, the contract administrator is the engineer. In the 1999 form, he's required to make a fair determination when he's called upon to do so. In the 2017 form, and although Janet said quite rightly, they're very, very complex, I've chosen just to deal with the 99 forms because they're still widely used, because people prefer them. The 2017 forms, the temptation not to tinker with it and improve it was not avoided. So a great team of engineers and lawyers produced the 2017 forms, and they've made them incredibly long and wordy and complex, and probably better. But I come from a perspective of the user on the ground who isn't the engineer. He's a delegate of the engineer, and people are afraid of those wordy contracts which need legal interpretation and legal advice often to understand. So the 1999 forms are still very popular in Malaysia for those who use them. But in the 2017 form, one improvement is that the contract administrator, the engineer, is to act neutrally. So the word neutrally has been brought in, which is a much better word, I would suggest, than fairness. Fairness is very subjective. Neutral, it requires an umpire. And having that sort of word and those sort of clauses in helps avoid disputes from the beginning and promotes fairness in the contract administration level to avoid disputes escalating. Thank you.
Thank you so much, gentlemen, for all the general comments. I'm now zooming into the clauses. I think we just want to be able to highlight. Maybe we can start off with PAM, given that Wyland said that they're largely similar, but there are differences. So in terms of payment clauses, is it the same, similarities, differences?
Yeah, there are a lot of similarities. Payment provisions in both the AIC standard form contract and PAM contract, you can find it in clause 30. So in both contracts, there are, payment provisions are in clause 30. And then there is also a similarity in terms of the procedure. For payment, the contractor will have to make a payment application to be followed by valuation and certification by the contract administrator. But insofar as PAM is concerned, the contract administrator is the architect. SFC is a neutral word, contract administrator. It can be an architect, it can be an engineer, it can be someone who is expert in administering the contract. And the other similarity, which is very important, is that it also gives the contract administrator the power to issue further interim certificate of payments after the issuance of the certificate of practical completion. So if the architect finds that he has missed out some other items, which he ought to have certified, but he did not, he could still certify after the certificate of practical completion is issued. And that is important because you do not want to leave those items which are missed out and nobody actually kind of disputing it. The architect is not disputing it, the contract is not disputing it. Sorry, the employee is not disputing it. And for the purposes of formalizing it, the architect has the power to issue an interim certificate. Now, the differences, I think, what are the improvements I think you can find in the AIC SFC contract is that we make certain terminologies clearer. If you find in PAM, the word final account is used for two purposes. One is after the works have been completed, they still use the word final account. You have to submit a final account for the completion of the works, the value of the completion of the works. And the other final account terminology is used in a PAM contract is after determination. They also use final account. But if you look at these two final accounts in these two scenarios, they are actually very different. The contract, the contents of this final account in a post-termination is different from a final account post-completion. But they do not have any definition, but they just generally use the word final account. But in SFC, we have actually provided differences in these two scenarios so that there is no mistake about, when you refer to a final account, what you really mean. And the other thing is also SIPA compliant. like in SIPA, if the subcontractor obtains a SIPA decision against the main contractor, under Section 30, subcontractor can actually go after the employer under Section 30 for direct payment to the subcontractor, provided that there is actually monies due from the employer to the main contractor. So instead of going after the main contractor, the successful, the winner in a SIPA decision by a subcontractor can actually go direct, bypassing the main contractor and go after the main, the employer. What if in such a situation, the employer actually pays out the money pursuant to Section 30? And if the decision is subsequently set aside by the court, either by the High Court or by the Court of Appeal, can the main contractor go after the employer? I told you not to release it, but you have released it, and it proves to be wrong. So to avoid that kind of dispute, we have made it clear, so long that the employer has paid the money pursuant to Section 30 under an adjudication decision, all right, then it will be deemed as monies paid by the main contractor to the subcontractor. Even if subsequently the decision is set aside by the High Court for whatever reason, the main contractor cannot go after the employer. So the main contractor will still have to take steps to recover the money from the subcontractor. Yes, so these are some of the features that we have actually put in. Actually, there are a lot more differences and improvements made in the SFC. These are the few things that I can point out to you.
Yeah, it's my turn now. So I've been asked to look at JKR and CIDB. JKR is very wide. In fact, the only two, I was actually only trying to look at the JKR 203A. But then I found there is, we must not forget our East Malaysian friends, And some of them are coming out with some good forms, And one of them, if you look, it's the JKR Sarawak form that came out in 2021. I think it's very well drafted, very well formatted and all that, and it's got some very good provisions, some of which are parallel to what AIAC has come about. AIAC, Wailun has gone through a lot of the so-called improvements. I'm not going to comment on that. I'm just going to point out some of the differences. Like, for example, if you look at JKR 203A, for example, okay, there are certain, some unique features among that which are not present even in PAM. And that is basically because of government policy. And one of the things you'll find, for example, in JKR, until the contract is signed, the contractor can only get maybe one payment or two payment. There are things like that, They put in things like that, which you don't find in AIC form. Of course, the other thing good about AIC form, which I feel is good, is we started when GST was there. You see? So the obligation to pay only arises after a tax invoice is actually presented. You see? Now we got service tax. It doesn't matter. And I think that's a very good feature there. JKR doesn't have that. Neither the JKR Sarawak or the JKR 203 has. Okay? So the other one is the timelines. If you look at the timelines, of course, government contracts, the timelines are quite generous. And sometimes I feel it is better to be generous and too strict, because if you're too strict in timelines, you default often and you'll end up going to SIPA and all that. So I think looking at that, I think JKR has got those, I think, things which are unique to themselves. Okay. And it's also reflected, if you look at it, in the JKR Sarawak form, because these are basically government forms. I have a bit more comment, which I also want to make about the AIC form. I hope Laiwood doesn't mind. I've raised it up earlier. One of the biggest problems we always have is with the final account. Okay, and most final accounts, if you look at adjudication, are not small amounts of money, huge amount of money, you see. And final account has been very disturbing over the years. We got final accounts dragging on for 6 or 7 years. Now, terminology again, if you look in a typical contract, okay, there are 3 types of certificates normally issued. One is interim payment, interim certificates while the work is going on. After that, normally we have only 2. One is the penultimate payment and then the final. Okay. Now, some of the forms have actually, mixed up, like what Wailun was saying. They're talking about some forms that you, within 6 months of completion or 3 months, you have to submit your final account. I mean, it's a bit misleading. Here, terminology-wise, I think AIAC form is very well written in that form. Now, what I think we can improve upon on the final account is, I do not know whether some of you are aware, the two big problems we always have in construction contract is getting proper and good, correct as-built drawings, and the other one is getting a proper final account. Now, the final account depends on your as-built drawings, isn't it? So what happens in most cases, if you look, even in the AIAC form, we are having that again. We are repeating the same thing. It's same thing in PAM. JKR also, even the so-called CIDB form, we have the same thing. Everything comes towards the end. We are talking about 3 months or 6 months after the certificate of making good of defects is issued, then only you start finalizing the final account. And it's a process where I always talk about it. I mean, in the industry, everybody has left. People who can verify facts are no more there. On the contractor side, he cannot come up with proper documents. On the client side, there's nobody there to verify it. And that is why it keeps on dragging on and on. There's no finality, and everybody plays ping pong, I prepare the final account and send to you. You find mistakes, you send back to me, And because of that, I think there's a trend. I do not know whether, I've encountered this in some of I still do some engineering work, fortunately or unfortunately, you see. And the trend nowadays is to finalize the account on an elemental basis. What do you mean by elemental basis? You finish the earthworks, you prepare the as-built drawings, so finalize the account for that. You finish the structure work, you finish the structure work, you finalize the drawings, you finalize the account. So you keep on going. So by the time you come to practical certificate, actually most of the money has already been paid. Most of the issues have been sorted out. So whatever little left over, like, unpaid variation orders and all that, you catch where? Penultimate certificate. And by the time you come to the final certificate, it are basically only defects. You see? One of the recent jobs I did, $120 million US dollar job, final account was only 6 million, you see? And it is actually something very practical and very good for everything. But yet all our forms, we do not have such a provision. And I think this is one area where actually we can improve upon. It's something we have to seriously look at, It's good for a contractor because the contractor, those of you especially, a client has already allocated a certain amount of money for a project. You don't use it, especially in the government, it goes back to treasury. Suddenly you come back with a massive final account. Where are they going to look for money? And here what happens, as and when the work goes on, you're actually paying off. So you have no issue on the as-built drawings, you have no issue on paying the contractor in time. Because one of the biggest problem, I said, one of the biggest areas of dispute, I always find final account. Whether it's an adjudication and whether it's an arbitration, and it's an absolutely nightmare because it's very difficult to verify documents. Now, the other area which I find is also not very well taken off in most forms, especially in government contracts, is to do with retention of title. We are paying for materials delivered to site. JKR pays up to 90% now. All our other forms we're paying 75%. And half the time, title has not transferred. And you look at our Sales of Good Act, these kind of Romalpa clauses if you have, and contractors and suppliers are beginning to actually enforce that. And if you want to look at some provisions which are very good at it, look at a telecom condition of contract, Especially telecom, you look at TNB conditions of contract, where they know especially these issues to do, especially when you terminate the contractor or the subcontractor is not paid. Recently, we had a case. Employer paid the main contractor for aircon. Main contractor did not pay his domestic subcontractor. What happened? He managed to enforce his retention of title clause. He managed to come and get a court order to dismantle the chilling tower and a cooling tower, and the employer to come back with 1 million ringgit again. So these are kind of areas which are actually still missing. Of course, JKR needs time to do that, For the other forms, I think we have to look into all that because otherwise, these kind of loopholes which are present are giving rise to a lot of disputes, a lot of claims and all that. So there are a lot of things to talk about, but I'll pass it to.
So just picking
Rodney,
up on
yeah.
the first point Harman's made about timescales for final account.
Yeah.
Here we have in FIDIC 56 days after the issue of the performance certificate, which is at the end of the defect notification period. So that could be 2 years plus. Whereas in our Malaysian standard forms, including AIC, it's 6 months, which is traditional, after practical completion. And I agree that 6 months is probably not long enough in reality. I mean, it's good to have timescales, which are shorter to get things done, but in reality, the market isn't providing final accounts within that time. So
no, but Rodney, if you go on an elemental basis, 6 months is more than enough.
Of course.
You see?
Course. I mean, so I think 6 months is
we
enough.
have to look at it holistically. We just
Yeah.
cannot, look at, Yeah.
What else is different? Looking at FIDIC, advance payment. There's no advance payment, as far as I'm aware, in the AIC form, a contractual right to advance payment.
JKR has.
JKR has, but in FIDIC, yes, there is. In the 1999 forms, there is, as of right, in the standard form. In the 2017 form, it's now an option to include for an advance payment, and it's an interest-free loan to commence work in exchange for a guarantee. So there is a protection for the employer, but it's recognized that the contractor should have an advance payment.
Rodney, can I interject here?
Yes.
I think just comment about CIDB form, which I could not do it. I think they have an option on payment bond, okay? Which is something very good and is something very, very practical. I think we should. In fact, Dr. Ong, remember when 2000 we were coming up with when you were the driver for the 2000 form, it was already proposed at that time and put in the 2000 form. Somehow it has not been picked up. I think perhaps it's something which AIC can also look at it. Why not? I think it's something very practical. Although it's an option. It's an option for the parties to exercise, but at least we give them that level of freedom. Sorry, Rodney.
No, not at all. No, that's a very good point. The procedures are very similar between AIC and FIDIC. The right to interim claims, the interim payment certificate periods. Sometimes it's stipulated in the appendix, other times it's 56 days or whatever. Period for honouring certificates, again, different, but the same principle. And then one little feature which is quite interesting, which always amuses employers, there's the right under FIDIC for the contractor to request the employer to submit reasonable evidence that there are financial arrangements in place to make sure the contractor is going to get paid. Not just in place, but will be maintained. Now, most employers delete that, of course. Again, that's a throwback to where FIDIC came from in developing countries, unlike Malaysia, which is a nice place to do business, and we don't have to ask employers like the big boys, have you got money to pay? It's a ridiculous proposition. But where there is a contractor coming into a country he's never been before, he wants the certainty. So FIDIC has that sort of provision, but that's not in any of the standard forms in Malaysia, including AIAC. So very similar between FIDIC and the AIAC, just those minor points of difference. That's what I have to say on payment. Thank you.
Now, I think I want to move on to a couple more areas before we, ask the question of, so how do we decide which form to use? Let's now move on to variation. Wylan?
Variation. I just would like to point out the differences in terms of the procedure. Why AIC SFC is better in that manner. For AIC form, when a variation work is completed, so the contractor, there's a timeline within which the contractor will have to submit a claim together with the particulars of the variation claim. Now, if there are insufficient particulars, then the contract administrator will have to inform the contractor within 14 days thereafter, after the submission. Now, whether or not the contractor complies with that direction by the contract administrator, the contract administrator will still have to proceed and value and certify the variation with whatever particulars he has. So there will be a closure. It provides a procedure that everyone will have to comply with, and there will be a closure. There will be a decision on the valuation and certification of the variation work done. Whereas in PAM 2006, there was no such timeline within which the architect will have to value and certify a variation. Normally what they did was that they will wait until the final account, then they'll only start looking at the variation. Now, the disadvantage of this procedure is that normally the architect will not attend to a variation, at least completely, and wait until the final account. And then at that point in time, they will give the employer a lot of leverage and start negotiating with the contractor and slash prices. You know, if you want the money, I give you 50% or something like that. So to avoid that kind of unfairness coming into place, we need to have a clear procedure. So in 2016, there was no timeline fixed for the architect to assess and certify a variation work. But there was an improvement or an amendment made in PAM 2018. I can tell you that amendment was after the AIAC standard form contract was published. So that actually idea was then sound off to the PAM committee, who then, I believe, taken it on and improved their PAM form contract and provided a timeline within which the architect will have to act on a variation claim. But that is still not complete insofar as the procedure is concerned, even in the 2018 PAM form. Because if there is no application or claim from the contractor, the architect is not obliged to unilaterally value or certify it. Because there's no timeline within which the contractor will have to submit a claim for variation work after its completion. Now, assuming that the contractor submits, then the architect will have to inform the contractor within 28 days thereafter whether the particulars are sufficient or not. If they are not, then the contractor will have to provide those particulars. Now, the trick here is this: whether the contractor complies with the request or not complies with the request, if the architect finds that the particulars are still not sufficient, he's still not obliged to assess, value, or certify. Now, this is the tricky point, because normally in a lot of situations, in the eyes of the contractor, they will say that I have already provided you whatever I have. It's complete. And then the architect will come back, no, it's not complete. And sometimes they don't even tell the contractor why it is not complete. And the matter just left it at that. Even though there is a lot of appeal letters written by the contractor, the architect just won't entertain. They just take the position that the particulars still not complete, and they are not obliged to assess and value and certify the variation. Now, the problem with this kind of procedure is this: if it is not clear, it provides a lot of discretion or leeway or loopholes in the procedure, then ultimately it will lead to a lot of disputes, unvalued variation work done. So it will keep on accumulating up to a point where the contractor can't take it anymore. Either they will just exit the contract, terminate the contract, and reduce the pace in the progress of the works, and everybody loses at the end of the day. So clarity in terms of procedure is important, and this is what you can find in the AIAC SFC contract.
It really sounds so far like a AIAC SFC form is the form to be used from here on. But let's hear the differences that you will see in a CIDB and JKR form, Harbans.
To put it quite frankly,
for variation.
JKR definition is very restrictive, compared to PAM, compared to CIDB, compared to AIAC, for example. And that is basically, I think, because of policy reasons, is restrictive, okay? And of course, all these forms, the similar characteristics there is an instruction is a condition precedent. Only thing, what happens if an instruction is purposely not given, you see? That gives rise to a lot of issues, So those kind of things, actually, there's another AIC form, I think nobody talks about it nowadays. It's a design and build form. I think we tried to address all those issues there. It has been also addressed here. But I just want to comment on a couple of things to do with variations, which I feel can be improved upon. Now, one of the biggest areas of contention normally is how do you value a variation? Okay. Now, the formula normally that's laid out in the contract, you look at it, and I'm not trying to say anything, don't get me wrong, everybody is just cutting and pasting, you know. The same kind of formula everybody is repeating. You see it in JKR, you see it in PAM, you even see it in AIC, you see work of similar character, similar this and that. I mean, to us, when we read about it, it can make a lot of sense. When you try to put it in practice, this is where all the arguments comes about. And I find most of the forms, whether it is the JCAT form or even the CIDB form or the AIC form, to me, I'm not a QS, I'm not a valuer, but I'm still a bit blur on that area. And this is one place I find a lot of arbitrations and adjudications. There's a lot of argument about it. Okay. Now, the other thing also there's a lot of argument is where, for example, where work has, you see, when work has got to be varied, there are two kinds of work. One is critical work, one is normal work, you see. And most of these forms is a common characteristic going through, okay. The so-called contract administrator instructs you must do. Valuation is later, you must do first, okay. Now, what happens if the work is not that critical? This is where the quotation system comes in, okay. You ask the contractor to quote, the contractor quotes, you go through, you agree, then you formalize in the form of a variation order. JKR doesn't have it. The CIDB, the new form, the 2002 has it. I think the AIC form has got it to a certain level. And I think that's a very good improvement. Because as I said, not all variations are critical. You see, you have time to look into it, you agree. You see, and CIDB now, talking about this collaborative approach, you know, that's their philosophy, you know, and I think this collaborative approach is also in a way present in the AIC form. So when you have that, you must give all the parties an equal opportunity, first thing, to vary. And second thing, all these things must be agreed before you formalize the variation order. It will cut down on disputes like mad. Here, what happens? I order you, I value, I take my time because there's no time frame for me to act, you see. So I drag it, like what Mr. Lam mentioned, not enough details. You know, I keep on, you know, like those days, I don't know whether Dr. Ong will agree with me or not. When I was working in JKR those days, we had actually, it was not in the conditions of contract, but there was a circular. Until the variation is finally agreed to, you pay provisionally. We used to pay provisionally 75% of the estimated amount. At least the contractor used to get something. We don't have that, you see. So these are kind of the areas, you know, I'm just commenting because there are not a lot of other areas to comment about, but this is what I'm talking about. We can look into it, and perhaps, I think AIC has it. Perhaps we can actually tinker it a bit, hone it a bit, and this will really avoid a lot of disputes. You know, Rod, on to you.
To add on to that, when we look at design and build contracts, EPC contracts, the mechanism there for valuing variations is pre-agreement of a proposal. Because the contractor is responsible for design and for implementation, the employer hasn't got control anymore. So he has to go and say, if I want to change, what's it going to cost? How long is it going to take? There's no reason why we shouldn't have that procedure in employer designed contracts as well. And as you said quite rightly, I think it's clause 1110 of the AIAC 2024 form, there is a by request for proposal. Variations can be by request for proposal first, and then the proposal can be considered and agreed upfront, which is a very efficient way to avoid disputes on variations. But the traditional way between AIC and FIDIC is by instruction, of course, and there are always disputes about whether an instruction is a variation at all, and the requirement for the contractor to comply and proceed when he may think that it's not an instruction. If he doesn't, then you can get all sorts of problems. But the variation clause in FIDIC and the variation clause in the AIC form are very similar. The definitions of what a variation are slightly different words, but essentially it's a change to the works. The power I've just dealt with to instruct. The power of the contractor to refuse, similarly in both contracts, if the contractor can't get the goods and equipment or the resources to do the variation, which is being instructed, then he can object in both forms of contract. The valuation of variations provisions are similar. Clause 12 deals with that in some detail under FIDIC. But as Harbans has said, in the AIAC form, it's very similar to the other standard forms, which is, in fairness, a tried and tested and workable process if you have the schedule of rates you need, if the documentation is in order, and if there's a will by those administering the contract to follow the rules. So it can work, although very often it doesn't. Additional expense, if there's loss and expense arising from a variation, a notice has to be provided under AIAC, which is a good thing. It's a loss and expense claim. It's a claim for compensation, so why not give a notice? The contract administrator under AIAC could cancel the instruction if he realized on notice that it's going to cost a lot more than he thought. There's no such requirement under FIDIC for a notice. There's no provisions in AIAC for value engineering, a proposal by a contractor to improve the efficiency of the work, the maintenance of the work by proposal, but there is under FIDIC. That's all I have for the differences.
Sorry, can I ask, Rod, how does FIDIC handle this issue of cardinal changes?
The same way as everyone else. It avoids it.
No, but is it properly stated?
Either it's a variation under the definition or it's not, but it doesn't specifically deal with any size of variation. It's just a change to the work. So potentially it could go, it'd have to be a legal argument about whether the change is too great to put the contract aside.
Yeah, but as you know, the cardinal changes come in two forms. One is the scope of work. The other one is financial limits. Yeah. Because I know, for example, government, their circulars are saying that it's limited, maybe I think 25% to 30% or something like that. Isn't it better if we incorporate it in the contract? Everybody is clear about it, you know? Because there's always an argument always there. Because then, you know, cardinal changes, contract rates don't apply. Yeah. Then the argument is always to do with the contract rates. Now, the other issue, I mean, also raising, since you're talking about FIDIC, you're talking about other forms, which you're always encountering is this so-called invalid variations, procedurally invalid, you know, you see, where works are taken away, given to somebody else. This is very common, you know. I had a case recently, you know, the moment the contract was awarded, the employer came in. The items that were more expensive, omit, call another contract, which were cheap, order the contractor to do it. I think this, you know, goes against the whole practice of, you know, tendering and all that. And yet most of our variation our clauses are very silent. They're silent on that. You leave it to common law. The contractor doesn't know anything about common law. You see? No, these are the kind of things, as I said, if we want to improve, we want to avoid, we try to clarify. If you want to clarify, I think you have to have some sort of express stipulations. In that sense, most of our forms are very silent on that. And I think this is something also we can look at the AIAC form when we want to improve it further. Yeah. Okay, sorry, Janet. Yeah.
No, so now I think, well, we've heard now similarities, differences, and also issues in the current standard form contract. I think nothing is ever perfect, but I think we should just still try and analyze two other areas, that is the extension of time and loss and expense. Maybe we can deal with these two areas together. Mylan, thank you.
Okay. Now, extension of time, there are two main areas of differences. One is that AIAC form provides clearer definitions on important terms. Like, for example, I won't go through all the terms, but one of the important terms, of course, is force majeure. If you look at and compare it with a lot of standard form contracts, the definition of force majeure, even if they provide one, are specific instances, specific kind of a definition. Like, for example, it is a force majeure if there is war or riot or something like that. Very instance-specific definition. But in AIAC form, we don't only provide examples of instances, because we can never be sure you know, what kind of force majeure which we can't contemplate now would also be fallen within that criteria. So what we provide, apart from the instances, we also provide the criteria of force majeure, meaning to say that if an instance happened or circumstance happened, which is beyond the control of the parties, and you satisfy these criteria, it will be deemed as a force majeure event. So you don't have to try to think of all the circumstances and put it into the definition of force majeure, so long that you have clear criteria provided as to what constitutes force majeure. And that is provided in the articles of the AIC standard form contract. And of course, the same goes to terminology like exceptionally inclement weather. And what does it mean? And there are actually criteria provided what it means. So if there is a scenario or extreme climatic condition happens, whether it would be deemed as an exceptionally inclement weather, then you just look at the criteria, and the criteria will give a clear guidelines for you to determine whether that extreme climatic condition would allow you to claim for an extension of time. Now, the second part that we'd like to deal with relating to this extension of time clause is condition precedent. In PAM, they have provided very harsh, clear condition precedent, which the contractor will have to comply with before they can actually entitled to an extension of time. Like, for example, when an event happens, the contractor will have to give a notice of intention to claim for extension of time within 14 days. And after the event ends, the contractor would have to provide all the particulars supporting the application for an extension of time arising from that particular event within 28 days thereafter. So if the contractor fails to comply with either of those conditions, the contract says that it will be deemed that the contractor has waived its right or entitlement to an extension of time. But in AIAC, what we did was that, yes, during the pendency of the contract, the course of the works, if the contractor fails to comply with the procedural requirements, only at that point in time, the architect was not obliged to assess an extension of time, but it still gives the contractor a second chance to make a final application for an extension of time after CPC, after the completion of the works, within 42 days thereafter. So even if there is a failure to comply for whatever reasons, because we look at our contractors here, the practice, the behavior, and also the resources that they have, very hardly you can find one contractor complies with those procedural requirements strictly. I mean, so far, out of 100, perhaps only one has actually complied with it, even though they know about this condition precedent, but they still find it very hard in practice to comply with those condition precedent. And I find it very harsh if you impose that kind of obligation so strictly on the contractor and they lose the right to an extension of time, because it would attract liquidated damages to be imposed upon the contractor, especially after the change of the law, cubic electronics by the federal court, which says that the employer needs not prove actual loss before they can actually impose liquidated damages, especially in those situations whereby the employer has himself been guilty or contributed to the delay, and yet they're entitled to impose liquidated damages. So the additional right given to the contractor in the AIC standard form contract is to provide another chance to the contractor. It is actually to balance out, the unfairness which you can find in those standard form contracts that provides very stringent procedural requirements for extension of time. But the same cannot be said to the contractor's right to claim for loss and expense, because if they want to claim for additional cost, the burden lies upon them to do it diligently and apply on a timely manner. If you don't do that for yourself, then you lose the right to claim for additional cost. So the burden is upon the contractor. If you want more money, you better do it and do it timely. The same cannot be said about the right to an extension of time, because as I said, there could be a situation whereby a non-compliance with a technical requirements under the extension of time clause, which then deprives the contractor of its entitlement, rightful entitlement to an extension of time, would lead to a situation whereby the employer could be unjustly enriched by imposing or deducting liquidated damages against the contractor, even though in circumstances the employee himself is guilty for the delay. So so that part is dealt with in the AIC standard form contract. And of course, the other requirement is that it is also SIPA compliant. If you are familiar with the provisions of SIPA, there is a section 29 in SIPA, whereby a contractor who is armed with an adjudication decision against the employer, and the employer fails to make payment in respect of the adjudication decision, then the main contractor can actually slow down the works or even suspend the works, and at the same time can still claim for extension of time and loss and expense. So in that kind of a situation, what AIAC SFC contract does is that we still provide you with a mechanism. Let the contractor in such a situation to apply for an extension of time so that that can be made clear. So make it fall within the purview of the contract administrator to look after all matters relating to extension of time and loss and expense, and not in a way where, okay, this is statutory rights, then you deal with it under the statute, and this is contractual rights, it deals under the contract, and it falls within the contract administrator. When all these are interlinked and intertwined, it has to be dealt with by the contract administrator. It only makes sense that if it does. Thank you.
Thank you, Wyland. So it looks like we are running out of time soon. We have exactly 4 minutes left. So I'm going to ask Harbans to just very quickly highlight difference in the CIDB JKR contract. Are they the same? Are they different?
Very tall order, but I'll do it very fast. All I say, JKR is not SIPA compliant. Okay. The grounds for claiming EOT and loss and expense is very limited. The procedure, to me, JKR 1 is unworkable because it's a unitary procedure. Okay. Now, I just want to comment. I'm more interested in commenting about CIDB because it's a new kid on the block. Okay. It has come up with some new concepts. And they are not treating EOT and loss and expense separate. They've combined it under a clause, I think clause 31, call it compensating event. Okay, they call it a compensating event, and they got a lot of these events. So in that sense, they're quite consistent with PAM and with AIAC. Okay, the procedure is a bit long. Okay, I won't have time to run about it, but I think they have allowed for most of the issues we have raised here. Okay, but I just want to make one last comment, or two last comments on all forms, including AIAC 1. Again, one of the areas where we always have got problems is adverse weather, exceptionally adverse. AIAC form also doesn't define it properly. The best definition is the JKR Sarawak form. They talk in terms of workable days and unworkable days, which I feel is very good. Okay. Now, the other one thing I want to comment about is every time you do an assessment when there's a dispute on a delay, issue delay analysis comes in. And then everybody is using a different criteria. The tendency is, why don't you put into the contract for them early on to agree on that, a common, actually a baseline to talk about, you know. So these are some quick comments. Of course, there are a lot of comments. I don't have time to talk about it. Rod, up to you.
Just very quickly, comparing FIDIC and AIAC in terms of EOT and loss and expense, I would say, may I stick my neck out to say, AIAC is a better drafted form because the way the EOT events, the time events are listed are employer responsible events or not employer responsible events. And then the loss and expense follows the employer responsible events. So it's very well drafted compared to FIDIC, where you have to go searching the clauses. Clause 8's got 5 items, one of which says any EOT provided for in any other subclause of the contract. And you have to get people like me to go through, or a lawyer to go through and list all the EOT provisions. So from a practical point of view, AIAC is much better drafted than the FIDIC 1999 form. But otherwise, they're very, very similar. Anybody who's familiar with the EOT and loss and expense clauses in Malaysian standard forms will be in familiar territory in the FIDIC 99 forms.
Rodney, thank you for summing up that very quickly. I did start out at this session having this question in my mind, and that is, how do we decide which standard form contract to use, given that there are quite a few options in the market? But I think from what this esteemed panel of industry experts have highlighted in this session, I think it's quite clear. It looks like the AIAC standard form contract did take into account a lot of issues that the industry is facing, and it is also SIPA compliant. So with that, I hope that we've also highlighted the key features of AIAC standard form contract. We are coming to the end of our session. I did say that if you have any burning questions, we will take them. But given that we have got no more time to take them, I will ask that you ask your questions at the next session. Thank you very much, everyone.
I'm going home already.
Thank you very much once again to our panel of speakers. Thank you very much once again to our panel of speakers and moderator for the insightful session. May I kindly request the panel to remain on stage, and we would like to invite Tan Sri Mohamed Ariff to come up on stage to present the token of appreciation for our speakers. Thank you once again to our panel. Ladies and gentlemen, before we proceed to the next session, let us take a short networking break. We will resume the session at 4:50 p.m. There are some light refreshments provided at the pre-function area next door. Please do join us there. Thank you. Ladies and gentlemen, welcome back to the event. Before we start with the second session, we would just like to announce that the AIAC Standard Form of Building Contract 2024 is now accessible through the QR code provided in your tags, and also the QR code that you see on the screen. We now go to the second session entitled A Path of Change for the Standard Form Contracts, the Expectations of the Construction Industry and its Future. This session will be moderated by Mr. Kevin Prakash, who is a lawyer, arbitrator, and adjudicator. Mr. Kevin Prakash and the panel is already here on stage, so take it away.
Thank you very much, everyone. It's 5 o'clock. We're scheduled to take 1 hour, but we're going to try to finish this a little before 6. It's at the end of the day and everyone's wilting. No long introductions, but everyone here knows. And if you don't, you should know Mr. Belden Premaraj, Mr. C.K. Un, and the Ms. Tan Sri Im. All three are practitioners here, lawyers, arbitrators, adjudicators, counsel, and together, of course, with the other members of the earlier panel, are out and out superstars in our practice here. Now, the session here today is titled A Path of Change for the Standard Form of Contracts, Expectations of the Construction Industry and its Future. Two perennial issues and problems always. Overarching questions all the time is, number one, what's a fair contract? What is fair to one is not necessarily fair to the other. What's good for the goose is not necessarily good for the gander. And the other issue is always this: the best drafted contracts, if not complied with by one party or the other, it becomes meaningless. And that is what always leads to all manner of disputes. Now, we have 5 questions that we are going to put to this panel of speakers here today. And generally they will be why standard form over bespoke? Evolution of the use of standard forms in Malaysia. Where are we now? Which is where they will explain to us, at least to their minds and their thinking and their experience, what the problems are and what the problems contractors now face. Where are we going, or where should we be going? And finally, their concluding thoughts. Let's see how much we can mine from these thinkers today, and at least in the next 30 to 45 minutes. I'm going to start with the first question, which is your reason why standard form over bespoke. I'll first invite Ms. Tan.
Hello, everybody. It's good to be back here in the auditorium to see a lot of old friends here. And thank you for staying with us on this Wednesday afternoon. So why bespoke? Why standard form? I think that the usual answer would be that if it's a standard form, we know what it's all about. If it's bespoke, then we have to actually read the contract. New concept called read the contract, and then figure out what is going on and whether you can or cannot deal with it. So I think that in general is what it's all about. Of course, there are many exceptions, and I'm going to pass the mic over to Belden because this is something we talked about the other day about how standard is a standard form.
Okay, now standard forms, when I was going through the list of why you should use a standard form as compared to a bespoke, you go through the normal arguments, familiar usage. All developers, contractors, consultants, they used to particular standard forms, and that's sometimes the problem of why AIAC and CIDB find it difficult to break into the market, is because the QSs obviously are the first in line to advise the developers, and they tend to lean towards, building, of course, PAM, engineering, IEM, you want international, it's FIDIC. So there is very little options when it comes to their mindsets because of familiar usage. But familiar usage helps maintain costs, helps negotiations. So there are a lot of positives in that. Another huge argument is that it's well tested in case law, and that in itself has a little problem that I will get to next. So-called fewer unforeseen anomalies. And then I saw this curious statement being made in an article that standard forms have a track record. So the next question is, what track records do standard forms have? Do standard forms actually end up resulting in projects completing on time because they actually provide for risk management and risk handling? Answer, generally no. Do they always end up with projects completing within budget? Answer, no. Do they end up really avoiding disputes? Answer, no. So track record of what? Right? The answer comes. Now, let's take I'll get back to that, because I think in the end of the day, it's the procurement structure itself that is the problem, not necessarily the particular standard form. Let's look at bespoke. Bespoke, yes, very complex projects. We need a bespoke contract. We need to innovate a contract into some interesting models that are used. But 90% of the bespokes I've seen in Malaysia, my own experience, I don't know about yours, is just drafted by a more powerful developer and tends to be developer or owner bias. So bespokes have ended up being tools of really risk allocation only one way. Standard forms have tried a myriad. Some standard forms tend to be more neutral, and then they're perceived by developers as being too contractor friendly. Some standard forms try and get a bit more owner friendly, contractors complain. But bespoke, I generally find they're all owner friendly only because it's drafted by a lawyer and the consultant team from the very start to pass all risk across. Now, today, I think that's the issue about standard forms and this one, which will swim into the next discussion about where CIDB is going. All the words that we're using, dispute avoidance, dispute resolution, nobody is talking about risk handling and risk management. Interestingly, in the UK, we know from the time the Latham report came out in 1999, followed by the Adgan report, every year, even in 2021, they are constantly thinking about changing the procurement modeling in order to create more efficient and projects that complete closer to time, if not on time, budgets closer to budget, if not on budget. These were the risks that they were trying to solve in contracts and not necessarily just allocate them. One great example is this whole idea of a notice requirement, which ends up merely allocating, transferring the risk of an EOT if the administrative failure of the contractor transfers the risk of the EOT and the delay to the contractor. Where is the mechanism for risk handling? So if you look at NEC contracts, look at how NEC 3 has developed in the UK, you realize they have moving on to new collaborative type of structures. We, on the other hand, here, and I think that's what AIAC, the challenge to AIAC is, it's an institution to educate. It should really look at changing the mindset of the industry. It won't be adopted first year, second year, third year, but over time, when people start to understand its usefulness, it may become the future tool in Malaysia too. So I feel rather than beat the same drum, standard forms, the same old procurement structures, it's the blame game. Who's at fault? Who's at fault? We have a mechanism to find out who's at fault. Rather than solve the problem first and deal with the fault later, there is no mechanisms for solving the problem.
Exactly. Which merges into the next question, Mr. Un, the evolution of the use of standard forms in Malaysia, and what were the considerations then when you were, and I understand you were involved, you as well as Ms. Tan were involved in the drafting of the early CIDB 2000.
Together with Dr. Ong Silen, who sits
together with Dr. Ong as well, who is right here. Give us your thoughts on the evolution of the use of these contracts here in Malaysia.
Well, on the evolutionary aspects of the use of standard forms in Malaysia, now I think most people will agree the most popular and the best value used forms is a PAM contract. As it is now, I think a lot of people have forgotten PAM contract was not always called a PAM contract. It was PAM stroke ISM 1969 contract. It started off with that. Then when PAM 98 came along, okay, which was widely said to be authored by Datuk Sundra, and which I believe. After that, right, okay, PAM 98, PAM came out in 2005, a contract which I was asked to comment, and which I have written a 20 over pages criticisms of it. And PAM later on, 1 year later in 2006, came out with PAM 206. And now the latest one, okay, PAM 208. So these evolution forms, the contract forms, the PAM form, the most widely used contract in Malaysia. And in fact, people call it the standard form of building contract in Malaysia. I'm not too sure whether there's a misnomer, but in terms of popularity and the usage, right, I think that you can say that, okay, it set the standard in Malaysia. But if you look at all these standard forms, now, each of the form, right, serve a certain sector of the construction industry. PAM contract is mostly used for building projects. IEM contract, the second edition of which I dropped the second edition, is used for private sector infrastructure projects, civil engineering projects, not building projects. Now, JCAL contracts is used mainly for government projects, but which has widely been adopted for a lot of private sector engineering projects as well. So now CIDB has come up with this contract, and the first edition came out in 2000, and Dr. Ong, Sri Im, and myself, right, okay, were heavily involved in this. And the latest one is just came out, I think it's CIDB 2023, if I'm not mistaken. Okay. Now, of course, there are PD contracts, which most international projects have been used in Malaysia, use PD contracts for, number one, if it's financed by World Bank or ADB. And on top of that, right, okay, there's a NEC contracts, which, to my experience, even though there's quite a lot of positive features in NEC contract, but it's still not much used. But one thing is important is this. Even though it is not contracting party, a lot of people have forgotten the role played by funders, the financial institutions, and their acceptance of a particular contract forms. One example is when I was advising a Malaysian company for a project in Manila. That project was financed by ADB, and they insisted on using FIDIC form. No others. Okay? So, over time, right, all these forms evolved, modified, commented by court cases as well, slowly being used and up to now. I can speak with some experience from the drafting of IAM contract. The first edition of IAM contract was started in the 80s. And at that time, right, it was so-called standard form of contract. And in fact, it was a contract, some provision of it was taken from JKL, some provision taken from the then, excuse me, the then ISM 69. So we jumble all this provision together, right? Okay, and this process of temporization has resulted in the IAM contract, which was published in the 80s. So when I drafted IAM, the second edition, which was published in 2011, I tried to make a change, but standard form contract being as it is, right, too drastic a change, the acceptance of which will not be great. So you cannot make too drastic departures from certain practices and certain provisions. And don't forget, certain phrases have been interpreted by court decisions. So it's not advisable to change them. So in a way, right, there are a lot of similarities in all the contract forms used in Malaysia. Now the standard form, right, consultation with stakeholders, I can speak with experience as well. When we published the proposed IAM standard form on the IMO website, there was hardly any response. Thank you.
Ms. Tan?
I'd really like to talk a little bit about where we came from to where we are, because the question that is being posed to this panel is about where we're going. So where we came from, and this talks about the various evolution of the forms, was that, way back in 1999 when Silen, Jikeng, and myself were dealing with CIDB, that was a very, very chunky contract. Take into account that at that point in time, the most chunky contract was Datuk Sundra's 1998 PAM form, and that was already considered wordy. If you look at the AIAC form today in 2024, it is even more chunky. It is even more wordy. Why is that? I can tell you that in 1999, when we were drafting, it was because we were trying to, inverted commas, address the ills of the industry. The ills of the industry at that point in time was that there was lack of procedure, there was lack of time frames, it was a bit loosey-goosey, and if it worked, it worked. If it didn't work, it failed spectacularly. So the CIDB form was kind of ahead of its time, and it had a lot of procedural requirements, step by step by step. Things that you used to find in project management manuals found their way into the contract form. Why am I talking about that? Because today, all those concepts that we had in that year 2000 form, which nobody wanted to use, perceived as contractor friendly, all those concepts are actually in all the standard forms. So the standard form has changed. But let me ask you this. And I'm going to use Rob Martin's words, has the will to administer in accordance with the contract, has that changed? Has that mindset changed? I think it has as well, but I think it's for the worse. That's my observation. So that's where we are today, Kevin.
Thanks. Thank you. Now coming to the third question, which is where are we now? And I think that question should be seen in this context, which is a lot of the problems and disputes arise, I think at least, from absolutely competing interests between the contractor and the employer or the subcontractors, and no one wants to give in, and you have both parties using provisions in their contracts against each other, or stealing a march, or doing anything that they can to either save money or to impose penalties, or to get ahead of the other party. If I can ask Mr. Premaraj first, where are we now? What are the issues that we're all facing today?
Well, coming back to the basics, competing interests is the name of the game. All employers start off the premise as they want something cheaper, but done perfectly. And the contractors, well, I have no choice. I have to go in with very low margins, but I'll find ways to make money elsewhere, or sometimes quality gets affected. Those two competing interests generally end up in risk flowing. Whatever your contract says, somebody is going to bear some losses. Both sides generally suffer losses throughout the project. Now, how do you solve this problem? And I did talk about the NEC standard form, whether that can be solved. That's a mindset change. Well, first of all, we have one problem with resource allocations, and I'm coming from the industry perspective. They have one Superman called the contracts manager, who will be managing disputes, managing the contract, managing the project, managing everything else. They'll have two project manager, contracts manager, and that's all they're willing to put on a job. So they don't have enough resources allocated to this whole project, to a contract that has a lot of administrative requirements, a lot of things to do, like the notice requirements get mixed up, because often this is the problem. We need to understand that what suits which project, what suits which type of contract, how much money is allocated towards administrating a contract is a very important point. So take an example of, I work with a client that uses primarily FIDIC. They are the biggest energy generator and provider in Malaysia. They use only FIDIC. They have used the silver book or the red book for the big power generating projects, and the green book, which has very little administrative requirements for the smaller projects, recognizing that the smaller contractors cannot run the big FIDIC contract. But even then, with the big FIDIC contract, because FIDIC has got a sense of fairness in how the administrative processes work, the engineer has to consult the contractor before making a final determination. There's a process for consultation, all that, and very often that also the employer himself fails, not just the contractor. So we find that that's one of our primary weakness in Malaysia, is the administration. As great as you put the mechanics into it, the administration is the problem. Now, how do we move forward is the important question. And I think that's where the whole idea of changing the mindset. I did something quite outstanding. I've never seen a contract like that. Scandinavian new attempts at this NEC, their version, creates what they call a problem with penalizing and blaming only. You go into a contract where it's all full of penalties and blame, it actually causes disputes. So they structure their contract even during the tender for the contractor to price in incentive amounts on benchmarks. And that incentive amounts on benchmarks then get used to mitigate a risk if it occurs. If it doesn't occur, the contractor gets it as a profit. And they started doing this, and they found people were thinking differently the moment they had an incentive, so the carrot worked, the cane didn't. The cane is there, all our standard form full of canes, LAD, any cane. Has that stopped the problem? No. So can carrots work better, or a mix of carrots and cane? That's a new concept that they are trying to structure the whole thinking in the Scandinavian countries, because they have a big time issue with all their projects, bearing in mind some parts, 6 months of the year, they are in total darkness. So they try to finish their contracts. Time is crucial. We've seen how it worked in the Olympics, in Olympic stadiums in London with the NEC3. It's a collaborative approach. My view is that, and I'm encouraging AIAC to take the big next step as being the leader of this industry, to move the industry forward to more collaborative types of procurement strategies, i.e. you draft the contract, they may not use it now, but someday they will. You go and convince the financiers that these are the right approaches, and they will start backing you. So I think that's where we need to go to solve the existing problem of today. The future is going to be hugely interesting because just a few months ago, I was in Paris and the ICC Commission on Arbitration, ADR, and the buzzword was AI. They expect AI in the next 10 years to do a lot of things and solve a lot of problems. So I've been thinking, how does that solve the problem here for construction industry? You will have a neutral AI fact determiner. So maybe that stops people from having to fight. But AI cannot stop a delay from occurring because it's still a human problem. So you need incentives, cane, and AI, and things may start to change.
Thank you. Mr. Un, I'll ask you both questions at once, which is where are we now and where should we go?
Okay, there's two questions, okay, lumped into one. I'll answer the first question first. Where are we now? Now, with the proliferation of all the contract forms, the first question we have to ask ourselves is this: are there less disputes now in the construction industry? Are there improved contract administration as far as projects are concerned? I think the consensus is no. There are more and more disputes, either appearing in courts or in arbitration. CIPA cases, right, okay, have been increasing so far. So the question is, what has the standard form of the contract role played in all this? Now, I just need to give three examples. As what Suim has alluded to just now, contract forms, right, even standard contract forms have been getting thicker and thicker. And I think the present AIAC form is about slightly more than 100 pages. Well, we have to face a reality. For example, right, how is the standard of contract administration in Malaysia? And on top of that, contractor, they are called contractor. But the contract is a document which you look at the list. Exactly. They are more interested in getting the job done than, for example, serving notices, so to speak. Now, come to the contract terms themselves. Okay, as I said, I'll just spoken in three aspects. One, the service of notices. It seems to me in the recent years, there's a hardening of judicial attitude as far as the service of notices is concerned. Take, for example, there are at least 2 court of appeal decisions on the failure to serve notice on time and is declared to be fatal to their claims or loss of expense. And the worst thing is, how do you compute the 60-day notice? It is not from the issuance of the certificate of delay and extension of time. It's from the day the events occur that you think you may be entitled to claim for loss of expense. So with all this coming in, and what happened to be a procedural misstep can defeat a substantive rights in contract. That's one aspect of it. The second aspect, all contracts in Malaysia, or indeed the common law world, there is someone called, for example, in PAM contract, the architect with a capital A. In the JKL contract and CIDB contract, the SO. And in IM contract or PD contract, the engineer with a capital E. And now in AIAC contract, the contract administrator. All this are what Justice Eka Yusof called professional middlemen in Pemilihan Liao Doctrine. But the question is, in the minds of most people, are they really neutral? Are they really independent? And I think that is still cause for doubt. Now, the next thing is what Belden alluded to just now on the concept of collaboration. I can only give you one example. When I was an external legal consultant to the Kementerian Kerja Raya, a standard relational contract was passed to me for comment with the aim of promoting it and also for wider use for JCAL contracts in Malaysia. 11, 12 years later, nothing seems to be heard from this. So that explains a lot. But if that would be accepted as what Belton said, I think we need a paradigm shift in our mental mindset. So these are 3 points I'd like to make. And where we are going right, okay, our professional middleman, maybe as what Belton said just now, maybe AI, maybe a better professional middleman in that regard. And the incorporation of BIM, okay, building information modeling system, maybe the next step forwards. But how, when would that be? I can't say for sure. Thank you.
Thank you. Now, Suim, I'd like to ask you to chime in with your views as well. But I'd just like to sum up some of the items that both Mr. Premraj and Mr. Un had mentioned, which is, for example, primary concern is cost and price, mindset, zero sum, free ride, focus on getting the job done before understanding the procurement strategy or a procurement strategy which is suitable for the job. Now, in the context of these points raised by Mr. Premraj and Mr. Un, what are your thoughts?
Back to the future. Back to the future, because I see in the audience many old friends. And together, we all used to have hair, or a lot more hair, and it used to be black. But these old friends and myself, today we are gray, we have much less hair. Where are we in the intervening period is the fact that at the end of the day, we have now what is effectively a broken system. Everybody, you go to every talk and every gathering about construction disputes, about construction, and they'll tell you the only people making money are the lawyers and the arbitrators. True? So why is that? Claims consultants, they're part of the ecosystem. So this is now a whole new industry. I mean, when I started as a young lawyer, arbitration is an unknown word. Today, it is an industry. It is a money-making industry all around the world. So we actually have effectively a broken system, which is going to take a lot to change. My colleagues speak to a change in mindset. I've been doing talks for 30 years. Been preaching about how to put me out of business as a lawyer. Actually, nothing's happened. Many of you know that I no longer act as a lawyer. I'm purely as an arbitrator. I'm still in business. SEPA was supposed to try and help cure those issues. But SEPA has its own issues that we have to deal with. So we now have a system that actually doesn't quite work. What's happening on the ground is not quite what's happening in terms of the contractual and the legal framework. And as a result of that, money is not flowing. So these are the sort of problems that we are dealing with. And I understand about change in mindset, and I wholly endorse it, and I would be 100% behind it. But I don't think I am going to see it in my useful lifetime. So I'd like to talk a little bit about what we can do in the meantime whilst these sea changes, these paradigm shifts are happening. In the meantime, and I come back to AI here, which is that first and foremost, the contracts that we have are the contracts that we have. You try and change them, I don't think you're going to be hugely successful. So accept the fact that when you build something, I don't care whether it's a process plant or a road or a building, when you build something, included in that scope of work is the paperwork behind contract administration. It is part and parcel of your project. Let's stop kidding ourselves that it isn't. Let's stop kidding ourselves that all we have to do is build it and the money will come. I think you found out that it doesn't, right? Then you talk about how do you do that? Everybody says got no budget. Well, if it's part and parcel of your project and your bar bender and supplier is in your budget, I'm sorry, letter writing, notice provisions has to be in your budget. But this is where technology comes in to help make this faster, easier, cheaper, we hope. We used to always talk about the fact that with computers and anything to do with technology, rubbish in, rubbish out. With AI, perhaps this can change a little bit more. And I don't believe that we in the construction industry are doing enough to use what's available in front of us. For Mr. Un to talk about BIM being the future, I'm sorry, Un, BIM's been around for the last 20 years. Everybody else actually has been doing it, but nobody's using it. And when they do use it, they're using it as a drawing tool. What's the point of that? So again, with AI, with apps that you have now on the market, and there's so many different things available. Well, I still remember when we first started using hyperlinking, somebody thought that it was such an amazing new idea. Again, so all I'm saying, guys, is that we have to actually live in the present, the reality of the present, but we can also use things from the future that are already at our doorstep to try to improve our ability to deliver what is needed in the present. But parallel to this, please, paradigm shift, mindset, let the money flow.
Thank you. Now, I just like to emphasize this. I might be guilty of belaboring these issues, but I want to put some of these issues back to the speakers, okay? Bear with me. Now, in respect of the employer not choosing or at least not developing a suitable procurement strategy from the start, that's one. Vis-a-vis the contractor, not familiarizing themselves early on with the terms of the contract such that they are not procedurally savvy, they end up falling into all sorts of problems because they're not complying with the terms of the contract. Is hiring a competent team a better way out? Now, these are the problems that contractors and employers are facing here and now. What are your thoughts and what is potentially a way out? Mr. Premaraj?
Like everything, competency and education tends to get you some way forward. But one little word comes coming back as a problem: not enough money. And then we also have another problem in Malaysia, and I saw that during the height of the expansion of building projects and projects in the Middle East, drained all our programming experts over there. Not enough programming people. And resource and money are the two big problems. In administration, it doesn't get rid of the risk, because risk needs mechanics and structure to try and get rid of it or handle it better, solve the problem on the spot. But if you don't have competent and education and you don't have the money to fund that, then it never will happen. So most of our domestic project parties come with very poor resource. We see that all the time. And that generally leads to one of the problems. Even the management skill is insufficiently resourced. The international boys have this aura that they will come fully equipped, but the jobs here are not profitable enough, so they too sometimes suffer the same problems. And we see the international boys also messing up in Malaysia because they are overstretched all around the world. And I always tell my clients, not the best come to Malaysia. So understand that. So therein lies the problem. Collaboration in a more incentive-driven way can go some ways to solving it. But it requires both the employer to realize if he pays peanuts, he will get a monkey to do his job, and he will suffer the delay and all the other things. He'll be chasing, oh, you sue, oh, I got LAD, oh, I got how much is your performance bond ready? How much is the retention sums? Oh, I got LAD, I can sue them. Yeah, you sue them. They'll go bust and you will suffer the loss at the end. So the reality is employers also have to wake up to the truth that margins are there for a purpose, delivery, but they don't see it that way. Finances have to be educated because developers in Malaysia have this attitude of always profiting as much as possible, and that just leads to a disaster.
Well, I'll echo what Belden has just said just now, okay? But I will add a few things. Number one, employers, being they are, right? But if you look at it, to know the problems, okay, let's look at the source. Now, a lot of times from my exposures and experience, the contract documentation is one of the main problems. Now, who did the contract documentation? Very often the QS. Now, what is this thing we call contract? Number one, contract documentation comprises, for example, conditional contract, which is the standard form you're talking about, drawings, specifications, etc., etc. And each of these, right, is prepared by a different set of professionals. And very often discrepancies, ambiguities will inevitably creep in. Now, I think you all have to understand that very few contracts were used in their own pure form, so to speak. A lot of times, letter of award, right, okay, will comprise 20 odd pages, repeating most of the provisions in the standard forms, number one. Number two, right, standard forms are having been amended by the so-called supplementary clauses, additions, amendments, and worse, they even amend standard forms provisions in the bill of quantities. So all this, right, whether the employers have any control or do they know about this, to me is a big question mark. Now, other than that, I will echo what Belden said. The lack of the proper persons to do contract administration in Malaysia. I do notice a trend. Contract administration in Malaysia has taken off after North-South Highway. However, it seems after the so-called Dubai move, a lot of people experienced and competent in this area has flown over to the Middle East. Thank you.
Thank you. This time,
That's the Dubai movement.
your thoughts, please.
The root of all evil is money. And I think that if you speak to consultants, I think that all the criticisms that have been leveled are true. But if you speak to consultants, they will tell you that their profession has been reduced and commoditized, and that you actually don't have the budget to produce what you're required to produce. Very often also, you are hired on a piecemeal basis. You can't hire your staff, and you cannot staff up to meet the requirements. So if you're getting poor product, I think that it also is a function of poor payment. But I don't want to leave you with the feeling of doom and gloom, because it seems to me that session 2, this panel has been rather gloomy. I think that we are being a realist, but I'd like to leave you with some thoughts about how things have changed in other places and how we could be doing the same thing. In Hong Kong, for example, the PWD form, I remember doing a talk about it way back in the 90s. And it was very much like a PWD form, whereby even unforeseen ground conditions was the contractor's risk, as an example. Today, I think it's been probably 8 years ago, where the Hong Kong Public Works Department, for large contracts, they're using NEC. So there is a mind shift that's going on. For Malaysia, I don't have statistics, but I'd like to just quote from some statistics from Saudi Arabia, because I came across this in an article in the website, the Global Construction Review, which is the website and the news portal of the Chartered Institute of Building. They speak to the fact that in Saudi, extra time sought, or EOT, is nearly double that of the original program. That there is on average 30% extra costs applied for, that change in scope tends to affect about 54% of projects. Closely entwined with that is scope creep, about 35%, and the usual immense pressure on the tendering team being given very little time and not being able to carry out due diligence. But as a result of all this, this article speaks to the fact that even in places like Saudi Arabia, employers are actually waking up to that fact, and they're investing more upfront to preempt these interlinked problems. So what I'm saying here is that it's not all doom and gloom. It's something that we can actually do. We can actually do something about it, but we've got to have the will to do it. So I ask for two things, please. One, put the will to comply with contracts for now, using as many tools as we have and can muster up, including AI. The second thing is to actually have the will to change and make all our lives better. And I will close off by saying, ultimately, I say again what I've been saying for 30 years, put us out of business. You're in the business of building, not in the business of disputes. A lot of people will be unhappy with me here because they're rice bowls. These are their rice bowls, and all of us have done well out of it, myself included, but we can do better.
I forgot to actually mention something about that Scandinavian experience and the incentivizing progress benchmarks that they provided. They also included an incentivized scheme for the project managers, project directors of the contractor. Employer gave them bonuses if they achieved their benchmarks. Then they created the treaty, understanding that humans will work 10 times harder to solve a problem if they got a nice fat bonus at the end. So it is realizing that we're not going to solve the problem in standard forms by putting beautiful words, nice administrative process, if we don't solve the human problem.
Belden, was that a flat pack project? IKEA, right?
It was linked to IKEA, but it wasn't.
It was like IKEA flat pack project.
Thank you. Now, I've come to my last question. Now, I'm going to ask for your views in turn, but these are some of the items that I hope you can answer in this final question, which is the SFC here to stay? Should the SFC be more or less prescriptive? The role of project consultants and the role of lawyers. Mr. Premaraj?
Well, sometimes the contract cannot be overly prescriptive because it is quite difficult for the contract to work out who plays what roles totally. You can have broad brushes, right? I think lawyers should not be even mentioned in the contract to start off with, but broad brushes. But of course, I think most projects, it's important to have these demarcation of roles, including the scope of work is well demarcated, who plays what roles. So I've seen contracts that add that as a schedule that has a demarcation of what sometimes in a certain things like regulatory approvals, the employer also has to play certain things. That can get a hang up and a lot of disputes. So you set up this schedule that sets out who does what, and then it becomes clear that's my job and not your job. So I've seen that work better because sometimes, again, it has to be set out in nice columns, like a spreadsheet, because these engineers and all this, they don't write lots of words, English words to try and understand. But you set them up and put the names, this is contractor, that is employer, that is consultant, this is architect will do this. Oh, then it became easier for them to follow.
Well, the question which Kevin asked was, is the centerfold contract here to stay? My very simple and straightforward answer is yes. Now, centerfold contracts, let's not forget about this. Is a centerfold contract used as a basis even for most, if not all, of the bespoke contracts? Now, secondly, centerfold contracts also set the pace, the standard provisions, and the usual provisions for which other contracts are based on. And on top of that, centerfold contracts should be, and I'm not saying they will be, more balanced as far as the allocation of race is concerned. It's not that lopsided. Now, I can give you one example of a bespoke contract which I've been asked to advise. And this is the issue regarding liquidated damages. And this is a pre-QB electronic days. The contract provision on LAD specifically says the contractor, after being imposed with LAD, shall not challenge the amount of LAD and the entitlement of the employer to impose LAD, and the amount of LAD is deemed to have the genuine loss, and if he has gone to arbitration, you cannot raise this as an issue. Now, whether this type of provision can survive Section 29 Contract Act is another issue, but it is written in black and white in the contract itself. So, bespoke contracts tend to be very lopsided, biased. However, standard form contract shows a direction on which what is more equitable. Now, for example, right, IM contract, PAM contract are sponsored by their respective organizations. They are professionals. I know the misgiving about them being employed, engineers or the architect in contract forms. However, they still have certain professional integrity and independence to preserve. So they will not, so to speak, come up with something which is drastically lopsided to one side of the contracting party. So standard form contract will continue to be used for these few reasons, which I said just now. And the question of the role of lawyers, I don't think, sorry, Sri Im, I don't think I can agree with you. This is lawyers committing professional harakiri. There will still be jobs for lawyers. There will still be jobs for other professionals, including claim consultants, in different aspects of contract administration. Even if there's drastic improvement in contract administration, leading to less and less disputes. And I think you all share my vision that the lesser the disputes, the better for the construction industry. As Srim rightly said, construction industry is in the business of construction, not in dispute resolution. Thank you.
Standard forms are here to stay. The AIAC standard form is actually a good form. I understand that it's not got the sort of a collaborative NEC type elements in it, but it is in constant development, and this is something that the AIAC does. I remember when it was actually launched, Datuk Sundra talked about the fact that he wanted a root and branch change to deal with the problems in industry from a root and branch. And this was what they're trying to do. But in addition to that is education. And where this is concerned, we started with a contract administration manual. And many of us were involved in that. And the intention was actually to have not just a manual, but also precedents, which we have drafted, and then to have a lot of workshops to actually explain to people, and that the root and branch change was not just the contract, but how this contract lives and breathes. And so I'm going to ask the AIAC, Datuk Sundra, can we bring back the project for the contract administration manual and the training that we were talking about when you first launched this project? I think that would actually help a lot the industry. So I asked that question, I'll leave it with you.
Thank you very much. I think this was simply an excellent discussion through and through. I've got no further questions for the panel. Are there any questions from the floor? Okay. Yes, sir. David. Sorry, AR David.
David, come and use this.
Okay, now thank you very much. My name is Architect David. I think I am an architect. I speak on behalf as being a contract administrator. Having known that the PAM form is the most popular form for private constructions contract, so most of us architects are basically contract administrators. And I heard what the panel has said, but I think I have a little bit, I can't agree totally to what has been said because it's almost put every blame to the contract administrator. But for the matter of facts, in order for the forms to work, the first person to actually be trained is actually the contract administrator. If the contract administrator don't even know what is inside the form, how would you expect them to administer between both parties? And that's where it leads to all the, what you call the dispute that enrich the lawyers, you see. I mean, I'm borrowing some of the announcers from Ms. Tan Sui Im there. And the other pertinent point is this. I think the statistic is not really realistic in the sense that, you know, assuming that all construction project ends in dispute. There is in fact a lot of construction project. I don't know about others, but as far as I'm concerned, my project has never ended into dispute as well. So these are the revelation is really not about the way the contract is being drafted. It's really about how the person manages to administer the contract. And that is very, very important. We are speaking among lawyers and so on. I noticed that there are a few architects friends with me around here. I think the fact is the architects, if they are given the position to administer the contract, they will need to know where they stand. And in view of the AIAC form, which I think is a good attempt to make it better than maybe the PAM's version, more importantly is to actually educate the contract administrator how good is this AIAC forms compared to the rest. So far as I can understand, the fundamental change is not there, right? Yeah, I agree with Ms. Tan Sui Im that, you know, the NEC is the best. I mean, not the best, but is the way forward, where people actually collaborate to complete the task. It's not the rights, it's actually the needs factor. They have to complete it by hook or by crook. Even with this administrative contract, you still have to complete it. But the fact is, when it is drafted by a professional that is not legally trained or something like that, there is a lot of imposition in the timeline that make it the whole thing very, very absurd in that sense. Especially when there is a notice that need to be given. Come on, if you are the architects for this project, don't tell me you don't know what's happening with the project, that the contractor needs to give you a notice to notify you what's happening on site. It's ridiculous, right? It's your baby to begin with. You designed it, and you can say that you do not know what's happening. I have to wait for the notice for the contractor to notify me of if there's an EOT required, if there's a variation required, or if there's a loss and expense required. Now, we also agree to say that the time and cost is almost the same thing. Why don't we evaluate cost and time together? Why must it be separated? Right? So these are something that is really troubling, that I can see there is a light at the end of the tunnel when we have this NEC contract, and now it's being mirrored into the CIDB 2022 contract, which I think should give it a try and test in the market how good it is. So this is the fundamental things that I think maybe in the future forms for AIAC, you can pick up and try to emulate. Thank you very much.
Thank you, sir.
David, can I just say that I agree with you about the contract administrator, but one size doesn't fit all, in the sense that you have people with right brain and people with left brain. Some architects I work with who are absolutely brilliant at design are horrible at contracts. Some of them are great with contracts, but their designs are absolutely boring. So we can't have one person to do everything. The same way that a contractor cannot have the same project manager doing every single thing. We all have a role to play, is all I'm saying.
Thank you. Thank you. Mr. Premaraj?
On the notice issue, actually, if you look back at the history of the notice requirements and how it evolved, it actually evolved as part of a mechanism for parties to know of a delay early on and try and work to mitigate it and solve it. It now became a weapon. It's weaponized by it being a transfer of risk if you don't achieve a paper administrative job. So if you look at the NEC, in the NEC, they set out a time frame for notice, but it immediately triggers a risk register, it triggers meetings, and it triggers solutions. So then if you don't give your notice, punish you. You're wrong. But here, you look at our contracts, no notice, thank you, the delay will occur. The delay will occur. Nobody will solve the delay. And at the end, contractor gets blamed for not having sent the notice. So that's where the problem lies. And the LAD as well, yeah.
Thank you. Mr. Chong?
Thank you, Chairman. Firstly, I think I want to say something which is trivial. Money is not the root of all evil. It is the love of money that is the root of all evil. Now, coming back to this standard form contract, I must say that this AIAC standard form contract is one among the many standard form contracts currently in use. I have no doubt that the expert advisory panel has done a great job in rebalancing the risk allocation, tighten some of the loopholes in the currently used standard form contract, and perhaps clarify some ambiguity. And also, I think I would agree if I take the word of the previous session chair to say that AIAC is probably the first among the equals. Now, what would stop an unscrupulous employer take the standard form, amend the thing, reallocate the risk according to his whims? I have seen one contract form, the time to file for EOT applications and the loss and expense changed from 30 days to 3 days. I'm not a practicing lawyer. I don't know whether in Malaysia there is an Unfair Contract Terms Act, but obviously this is unfair contract, right? Now, I support what Belden said. Malaysia doesn't need another form of contract that tightens all the loopholes, but what we need is a collaborative standard form of contract that incentivizes the party to complete the project rather than to incentivize the party to tighten the contract to their needs. And in that sense, I think AIAC should push the envelope and come up with some kind of partnering or alliancing contract that actually incentivize both parties, not just one. I have seen contract that incentivize the party to redesign, but all the saving went to their employer. So what is the incentive? There's no incentive. You must give the party who make an effort to redesign the project the benefit of the saving as well. May not be 100%, at least 50%. Thank you.
Thank you, Mr. Chong. Any comment?
Comment to that is that I agree with Mr. Chong. We are where we are, but we need to reboot. And reboot is where the future is. So that's why I speak to both what we need to do today, because the future will take a little bit of time coming. As I said, I'm not sure I'll see that in my useful lifetime, but that's the way to go. Agreed.
I think stopping someone from amending a standard form, you can't. They want to amend, they amend. But if we, let's say, in time to come, create a collaborative, something which has more collaborative, and I believe Malaysia, we shouldn't jump straight to NEC and copy NEC, because I don't think Malaysian market is ready for NEC. It requires a lot of maturity, it requires a decent amount of administration. Baby steps lah. The next draft, we look at some improvement and bring in more collaborative ideas into a contract and keep baby steps, new addition, another step comes in, people get more used to it. And one day when a contractor who redrafts a contract finds that his project constantly has problems and the ones that don't have problems, maybe the day finally the penny will drop. But we need to run road shows as well to educate developers. But often we are talking to contractors, right? But we don't very often get the opportunity to talk to developers of big projects because they are behind the scenes and they get a concession and then they suddenly come out and they talk to only their feasibility guys and the consultants. So we also have to change the mindset of consultants. I think that's the problem. That is going to be a challenge to change the mindset of consultants to use a complete different form than the form from their institution. That is going to be a tough ask, because there is a link to the institution. But we need to go there. I agree.
Thank you, sir. Mr. Wood? We have just crossed the 6 p.m. mark. Are there any further questions? If there's none, then we'll bring this session to a close, which I thought was an excellent discussion and discourse today. Thank you very, very much, Mr. Premraj, Mr. Un, and Ms. Tan.
Thank you very much to our panel of speakers and moderator for the very brilliant session. May I kindly request the panel to remain on stage as we invite Mr. Michael Chai to come up to present the token of appreciation to the speakers. Thank you so much to our panel. With that, distinguished guests, ladies and gentlemen, we have come to the end of the official launch of the AIAC Standard Form of Building Contract 2024. And we are eager to meet you all once again tomorrow for the launch of the AIAC Islamic Standard Form of Building Contract 2024. Without taking much more of your time, we kindly invite you to join us for a networking session at the pavilion above the car park. That is all. Thank you and have a good evening.